All right, Rita Tinino reporting. We still have a lot on the SGR to talk about. Joining us now on phone is Gladys Boss Shollei. She's first an advocate of the High Court of Kenya, even before being a representative from Uasin Gishu, and now she's a leader in the National Assembly, the Deputy Speaker in the National Assembly. Gladys, good to talk to you this evening. Perhaps my first question regards what I have seen online, and this is a legal agreement. In essence, it's a contract. Is there a difference? Because they say that perhaps we have not seen the real contract. What we are seeing are payment agreements. Could you first clarify that for us?
Let me clarify. First of all, this is an agreement. It's a contract between the Exim Bank of China, which is under the Ministry of Finance in China. That means it is the government of China, and the borrower is the government of Kenya. Interestingly, this should actually be a bilateral arrangement between government to government. But instead, Kenya, in the contract, has waived its immunity as a government and is subject to private commercial law. Okay. That is basically, we have exposed Kenya. Okay. Because under our law, Mijungu, we have the Government Proceedings Act, which gives the government immunity such that should you be in default, the property of the government of Kenya cannot be auctioned. But we have waived in this contract that immunity. Therefore, China is capable of auctioning government property. That is extremely unprocedural. We have therefore lost the protection that we normally have as a government.
Okay.
The other issue that is wrong with this contract, let me just explain to you something else that's wrong with this contract.
Okay.
This contract also says, should there be a dispute, it will be subject to arbitration. That is very well. But it says that the seat of the arbitration shall be in Beijing, and the address of service shall be the Kenyan embassy in Beijing. And it is deemed that Kenya has been served within 14 days, within 15 days, even though the diplomatic parcel has not left Nairobi, has not left the mainland of China. Meaning, they can serve us, make it impossible to send the parcel to Nairobi so that government can instruct its lawyers, and therefore, we will be sitting ducks. And furthermore, the arbitration is supposed to be done exclusively by the China International Economic and Trade Arbitration Commission. This is an agency of the Ministry of Trade of China.
Okay.
And the arbitration rules and the applicable law is Chinese. And it also says that in the absence of an agreement, the language of arbitration shall be Chinese. And obviously, we don't have an agreement to say otherwise. Therefore, in a nutshell, what it's saying, the question we're asking is, how do we expect to get justice against a Chinese agency when the forum is a Chinese agency and the arbitration is held in China in the Chinese language, they're represented by designated Chinese legal representatives? It's mind-boggling. As a lawyer, I can't believe that you could actually put those clauses.
You've taken me aback tonight, because the most important question, the fundamental question that I have to ask at this point, you having said that is, I have other questions, but what were they thinking, Gladys, when they signed this contract? What were they thinking?
And no, it is, if I were the Attorney General of the Republic of Kenya, this is a no, no, no. Even negotiate that the forum be done in a neutral ground, the arbitration. But like I said, in simple words, if you don't like the contract or you have a dispute with the contract, you are going to be having it, the arbitration to be done by a Chinese agency. And then it will be done in Chinese. And the applicable language, like applicable law, is Chinese. And the legal representatives designated shall be Chinese. So already you're starting from an extremely weak point.
It's like a foreign investor Yes. Some of the things you're telling me, Gladys, are standard in contracts. But I want you to look at this contract because they're standard. People always take advantage, especially the financiers, and we were begging for this money at that time. So definitely they had to lord over something. But the question that Kenyans need to understand, in your mind, was this deliberate? Was it overlooked? What exactly went on in this contract?
Obviously, for some reason, China had the upper hand. I can't understand what undue pressure they had over the government and the Attorney General of the Republic of Kenya at the time. Because it's like saying a foreign investor transacting with Kenya signs an agreement to say Nairobi shall be the seat of arbitration, and also say that Nairobi Center for International Arbitration, which is our forum in Kenya, shall be the forum for arbitration, and saying that it shall be done in Kiswahili.
Yes.
And that service shall be deemed to have been effected, provided it's been given to an embassy in Nairobi, even though the documentation, the arbitration documents and all the case documents have not left Nairobi.
Yeah.
Because effecting service, I mean, as a lawyer, how you receive the documents to know what the dispute is about is through service.
Indeed.
So what is very, very important and of essence is that your lawyers must receive all documents so that if you're supposed to respond within 15 days, they will have received the documents. It's standard procedure.
It's standard, yes.
We saw the Supreme Court matter the other day. You receive, the moment you receive service, they start counting the days of your response. So in this case, they don't have to have left the mainland of China. Why they put such a clause doesn't make sense.
Okay.
And also another part of the contract that I've seen that is suspect is it says that it doesn't mention the Mombasa port, but however it says that it provides that the government of Kenya shall set up a Nairobi inland port and institute mandatory customs clearance of the cargo coming through the port of Mombasa to be done there.
Yes.
That means they forced us to say the clearing place will not be Mombasa. It shall be the inland port, which we must undertake. So they basically dictated the inland container depots, port clearance. And then it says, at the same time, it gives the lender, that is Exim Bank, the right to examine and supervise the execution and performance of the security document.
That's technically handing over that power to Exim. They make absolutely every decision regarding this contract, whichever way they wish.
Unless there's another document that I haven't seen, but from what I've read, this is what I'm telling you and what it says. So basically, what the contract, that part of the contract is saying, it binds the borrower not to assign the contract to anyone else. That means Exim Bank can wake up tomorrow, assign the contract to the government of China,
and there's nothing you can do.
And there's nothing we can do.
Yeah.
And create other supplementary agreements without disclosing what those adverse terms were.
Okay.
So it's pretty interesting. Yes. And I've just picked maybe 5 points.
Yeah.
I think I have like 30-something.
I know. So
I'm enjoying this actually.
Yeah. There's the other question, now that you've talked about disclosure, there's an element, there's a clause there that prohibits the disclosure of the contents of this agreement publicly unless by court. Was this the reason why you think the previous government failed to disclose this information, regardless of the fact there were several court orders that actually mandated the government to disclose this to the public?
Yes, and I think when the members of the public went to court saying that they wanted a disclosure of this, I don't know why, I don't think I remember the Attorney General arguing that we have a non-disclosure agreement. They never said that. So it's also, they even hid the fact that there was such an agreement.
Okay.
Yes.
So finally, as I let you go, just in 1 minute, this is supposed to be referred to Parliament. The CS Transport Infrastructure said it's going to Parliament, probably to a parliamentary committee, then it will come to the floor. In just 1 minute, what do we expect? What is the outcome? What will happen in this?
It's not happened before in a situation where we are discussing an agreement after the fact. But I think Parliament always has the opportunity to discuss something of grave national importance. You can adjourn the House just to discuss that. And based on that, some actionable points can actually come out of it. So it's a new. I don't have a precedent for it.
Okay. Okay.
Yes.
Thank you so much.
But I'm sure we can come our standing orders and figure a way of having it go back to the relevant committee, and then based on that, there can be policy decisions, legislation decisions, and even just how to renegotiate this. Okay. But it also teaches us going forward how not to sign contracts.
All right. Thank you so much. This is a conversation that must continue and will go on until we fully understand this. The first thing that I'm glad is at least there are English versions of this contract. Thank you so much and all the best in Parliament. Gladys was speaking to us live there on the issues of the SGR contract, and we'll definitely continue with this discussion whenever we have an opportunity.